In this lesson, we're going to go over the most frequently tested and highest yielding areas of constitutional law on the bar exam in 60 minutes or less. Now, having the opportunity the last week or so to go back over every single constitutional law fact pattern that's been released by the National Conference of Bar Examiners from 1997 until today, and just based on the data, I can tell you guys, unfortunately, constitutional law as a subject is a little bit less predictable than some other bar exam subjects, at least in terms of the essay portion of the exam. So constitutional law will require a little bit different of an approach than some of the other videos in this series. Nonetheless, even though the approach is going to be a little bit different, I think it'll be equally effective, right? Because one of the biggest problems in constitutional law for most students is seeing the big picture, how the entire subject fits together. So our focus in this lesson, rather than trying to pick one area of constitutional law that's more frequently tested, we're going to just try to break the whole subject down in 60 minutes, right? So you can kind of see how things fit together. So here in this lesson, it is going to be important under the video. It's always important to do this, but under the video, we are going to have a lot of notes, some more deep dive things to consider, some more exceptions and other limitations to think about if different areas are tested. Again, the primary focus here, though, is just going to be to give you guys the idea and some of the more confusing stuff, how it all fits together, right? Things that are just pure memorization, I'll put below the video, right? If it's easy, if I don't think there's a lot of critical thinking and analysis there, we can put it below the video and you guys can just take a look and memorize that. But what I want to focus on here is the big picture stuff and really just try to break down the subject as a whole, because again, unfortunately, right, constitutional law is just one of these subjects, and really there's only a couple subjects that are like this that is less predictable. So we're going to do the whole subject, break it down so you can see it from the big picture and kind of work in, right? So with that being said, I'm going to set the timer to an hour right here, right? And we can just go ahead and start this. So the clock is now officially going, right? So constitutional law, fortunately, we can break up into three major categories and three major issues, right? Number one, we have power of the feds. Number two, we have federalism. And number three, we have individual rights, right? Power of the feds is going to come up anytime we see a federal government actor taking some sort of action, right? Whether that's the Supreme Court or a federal court, Congress, or the President of the United States, right? If we see any of these parties taking any kind of action on our constitutional law fact pattern, we have to ask the question, well, does the federal government have the power to take this action under the Constitution, right? We know Article 1 of the U.S. Constitution vests the power, the legislative power in Congress. Article 2 vests the executive power in the President of the United States. And Article 3 vests the judiciary power in the Supreme Court and the federal court system, right? So if we see any of these parties taking actions, right, a federal court's hearing and deciding a case, or Congress is passing a law, or the president is negotiating a treaty, issuing an executive order, whatever the president's doing, right? We see any of these parties taking an action on our fact pattern. We have to ask, do those parties, does the federal government have the power to take these actions, right, under the U.S. Constitution, right? This is the idea of power of the feds. It's establishing that whatever action the federal government is taking, they actually do have the power vested to them in the Constitution to take these actions, right? This is kind of our first bucket, our first category of issues we're going to go over. Next, we'll move into federalism, right? Federalism deals with the relationship between the federal government and all the state governments, right? And really the way that this presents itself on the bar exam is when we see state actions that conflict with the federal government, right? So we'll ask, does the action of a state government conflict with the feds, right? And here we'll see that there's some powers that are exclusively federal powers, some powers that are exclusively state powers, but most powers we'll see are actually concurrent. Both the federal government and the state government can exercise these powers, right? If you've ever paid a federal income tax and a state income tax, right, you know that there are concurrent powers, right? The federal government and the state government have a lot of concurrent powers they can exercise over you, right? So the question will be, what happens when there's conflicts, right? If we have these concurrent powers, what happens when the federal government and the state government are doing things that kind of overlap and clash with each other? How do we handle those issues? That's the concept of federalism. So anytime on a fact pattern on the bar exam we're seeing some sort of conflicts, different tiffs between state governments and the federal government, we know to think about these federalism issues we're going to go over, right? Predominantly being the Supremacy Clause, preemption, and the Dormant Commerce Clause. Finally, our last bucket that we're going to go over here, and the last kind of third issue you want to think about, is individual rights. This is usually really easy to issue spot on constitutional law fact patterns. Anytime you see the government passing regulations, right, whether it's a state government, a local government, or the federal government, right, Congress is passing laws, we have to make sure that those actions, right, those regulations don't infringe on an individual's constitutional rights, right? And the big ones we're thinking about here are substantive due process, equal protection, and free speech, right? And these are the three we're really going to break down at the end of this video. So we want to make sure, right, that if we have a regulation, right, step one will be, right, imagine we have Congress passing a law, right? We'll have to ask, number one, does Congress have the power to pass this law? Number two, does this law infringe on any individual's constitutional rights, right? If we see a state passing a law, well, we'll have to ask, does this state action conflict with the feds? And also, does this state action infringe on an individual's constitutional rights? So anytime you see a law being passed, whether it's a local law, a state law, or federal law, right, you immediately know that two buckets will be triggered, two major issues will be triggered. Now always, right, as always, you'll read the call of the question. You won't talk about anything that's outside the scope of the call of the question on an essay, but just in your head as you're reading the fact patterns and you're thinking about those calls of the question, it's good to keep these three buckets in mind and really try to sort in your head what we're talking about, right? It's really going to help you issue spot as you go through fact patterns. But we can start with our first major category, right? Power of the feds. Remember here, anytime we see a federal court, the Supreme Court, a federal court, Congress, or the President of the United States taking an action on a bar exam fact pattern, we're thinking, does this party have the power to take this action? We'll start with the Supreme Court and federal courts. So here, anytime we see the Supreme Court or the federal court hearing and deciding a case, right? A case comes before them, they're going to issue their judicial power, right, to review the case and issue a ruling, right? They're going to exercise that Article 3 power. We have to make sure that they actually do have the power to take this action, right? And we'll start with the 11th Amendment, right? The 11th Amendment is a jurisdictional bar, right? And this will come up if we see a state as a defendant, right? So here, if we see an 11th Amendment issue, what it'll look like, right? We'll have a plaintiff, right, suing a state, right, in federal court. That's critical. It'll have to be in federal court. If we see this, right, it's that simple. A plaintiff suing a state in federal court, we're thinking 11th Amendment, right? 11th Amendment is the state sovereign immunity clause, right? The 11th Amendment provides immunity to states, right? So this could be like Texas, right, to agencies of the state, right? This would be like the Texas Department of Public Safety, all the departments and agencies of the state, and state officials. This could be like the governor of Texas, right? All of these parties have immunity in federal court, right? So if a plaintiff is suing a state agency, or a state official in federal court, our starting point rule is going to be the 11th Amendment actually provides immunity if these defendants wish to exercise that immunity, right? If you see the state, a state agency or state official as a defendant in federal court, 11th Amendment provides these agencies, the official, and the state immunity under the state sovereign immunity clause of the 11th Amendment, right? So there are some exceptions to keep in mind here. Number one, we have consent, right? As always, a state can consent, right? Even if they have immunity, the state can waive that 11th Amendment protection and consent to being sued, right? If we have a state official, like the governor of Texas, it's important to ask, well, who's actually paying the bill, right? Who is paying, right? if the actual state is paying, right, state funds are being used, right, if the plaintiff is successful, he's going to recover state funds, right, then that official can exercise 11th Amendment immunity. But if the official is personally liable, 11th Amendment doesn't apply. Imagine we just have a car accident, right? Plaintiff gets into an accident with the governor of Texas, right? Plaintiff is from Florida, right? Texas governor is going to be a citizen of Texas. Imagine it's a $100,000 personal injury case. Well, we know the federal court's going to have diversity jurisdiction to hear the case, right? If we remember back from civil procedure. And here, just because he's the governor of Texas, right? The defendant's the governor of Texas, doesn't just give him absolute immunity, right? He's personally liable for this car accident. Texas funds won't be used in a personal injury case, right? So here, just because you're the governor of Texas, that doesn't give you absolute immunity in all lawsuits in federal court, right? That would not make sense. So in this instance, right, you always ask if you see a state official footing the bill, right, then you know, okay, 11th Amendment doesn't apply. If a state official is being personally liable, is being held personally liable, they can't exercise their state sovereign immunity under the 11th Amendment. The other big exception to look out for would be congressional authorization, right? Congress in the actual statute says that they're abrogating 11th Amendment state sovereign immunity, right? They're basically saying, hey, look, if you're sued under this cause of action we're creating in this act, right, being passed by Congress, you can't exercise immunity under the 11th Amendment. They can actually put this, but they have to do so clearly and expressly, and it has to relate to the enforcement of the 13th, 14th, or 15th Amendment, right? If it's for any other reason, the state can still exercise immunity, right? The abrogation clause would be invalid. But you'd want to look out for that, right? An actual abrogation clause in the act passed by Congress, right? That creates the cause of action that the plaintiff is relying on. If you see that and it's done so clearly and expressly, which has to be given to you in the fact pattern, right? It'll actually say, right? I have a fact pattern right here, right? Here it says, this is just a statute from a prior bar exam. Section 204 provides that any action brought pursuant to Section 203 may be brought in federal or state court, and that if brought in federal court against a state, its agencies, or subdivisions, any defense of immunity under the 11th Amendment to the U.S. Constitution is abrogated, right? That's an abrogation clause. Now, the reason that on this bar exam fact pattern it was invalid is because it didn't have anything to do with enforcement of the 13th, 14th, or 15th Amendment, right? This was a Violence in the Workplace Act, right? Nothing to do with involuntary servitude, due process, equal protection, or voter rights, right? It's just a violence in the workplace statute. So Congress can't put an abrogation clause on state sovereign immunity in that case. So even though they put an abrogation clause and they did so clearly and expressly, it's invalid, right? Because this isn't enforcement of the 13th, 14th, and 15th or 15th Amendment, right? So that's 11th Amendment, state sovereign immunity, right? Anytime we see a defendant being a state agency, or state official, we're thinking 11th Amendment, right? Next, we have justiciability. Justiciability, I'm going to switch markers because this one's running out of ink. Justiciability, right, comes down to three elements, right? We have injury and fact, right? We have causation, and we have redressability, right? These are the three elements of standing, but, right, the justiciability doctrine is really all about requiring the requirement under Article 3 that federal courts can only hear actual cases or controversies, right? The federal courts are not allowed to issue advisory opinions based on hypothetical fact patterns. Basically, we need a plaintiff who's actually sustained either a real injury or there's a very imminent threat of an actual injury, right? We say, though, that there has to be some sort of particularized and concrete injury for the court to have standing to hear the case before it, right? In order for the plaintiff to have standing, which is a requirement for a federal court court to hear and decide a case before it. So justiciability is just all about whether the court, the federal court, can hear or decide the case before it, right? If they can hear the case before it, we say that's justiciable. If they cannot hear the case before it, we say it's non-justiciable, right? That's where this word justiciability comes from. And on the bar exam, what we're really focused on is these three elements, right? We'll say in order for the case to be justiciable, right, to satisfy the case or controversy requirement under Article 3, plaintiff must establish the following three elements, right? And this is going to be able to show the plaintiff has standing, right? Number one, that they've sustained an injury in fact. Number two, the plaintiff can trace the injury to the defendant's conduct. And redressability, meaning if we find in the plaintiff's favor, it's actually going to provide redress for the plaintiff. Injury in fact is really also related to our ripeness doctrine, right? Here we're thinking ripeness, here we're thinking mootness. You can just write it all up. These are all the hot button words you'd want to think about on the bar exam, right? So common instances where a plaintiff is bringing an action but they haven't sustained an injury would be laws that are created but not really enforced, right? Imagine that the federal government, or it doesn't matter who, right? Someone makes a law, some lawmaking body passes a law that says newspapers are not allowed to say anything negative about government officials, right? Probably a clear First Amendment violation. But let's say this law is never enforced, right? But a reporter for a news agency sues, right? Problem is, he's sustained no injury, right? The case is not ripe. The case hasn't ripened yet. This reporter needs to actually have this law enforced against him to sustain an injury to bring this cause of action, right? Without an actual injury in fact, right? It's just a hypothetical fact pattern, right? And federal courts cannot issue opinions on hypothetical fact patterns, right? We need an actual injury or some imminent threat of an injury, right? So if we just have a law that's been sitting on the books for 20 years and never been enforced, and a plaintiff tries to just bring an action under that law, it's not ripe. They haven't sustained an actual injury in fact, right? Causation is a lot like Paul's graph in torts, right? It's all about whether the plaintiff can trace their injury to the defendant's conduct, right? A lot of examples we could use here. One of the big ones, though, that you'll see is in taxpayer situations, right? A taxpayer tries to challenge a government expenditure, right? They're not going to be able to trace the government's spending of their money to their actual injury, right? Once you pay your taxes, they get commingled into a giant fund. You don't know where your tax money actually went. That's why for most expenditures, right, we say taxpayers challenging expenditures generally don't have standing. It's this second element. Now, in some cases, they might, right, challenges of the Establishment Clause, very rarely tested, right? The main thing to recognize here is the defendant or the plaintiff has to be able to trace their injury in fact to the defendant's conduct, right? You also see this in tax initiatives, right? Imagine that the government says, we're going to decrease the amount in charitable donations you can get by 10%, right? So people on their tax returns get a 10% reduction in their charitable donations. This leads to less people making charitable donations. Say a law student exists out there who's using books at a resale shop and there's now less books on the law. So they argue, look, I got kicked out of law school because there was less books on the law, and they try to trace it back to that tax initiative, right? That's going to be very hard to trace. The harder it gets to trace the injury to the conduct, right? The longer, more attenuated it gets through that chain, the harder it is to prove that second element. So if a tax incentive is passed, and that creates some behavior, and then something else happens, and something else happens, and the plaintiff is trying to trace their injury back through this chain, the more things that happen along the chain, the harder the second element is to prove. If we don't have causation, it's not justiciable, right? The federal court does not have the power to hear and decide this case. Redressability, right? This usually goes hand in hand with mootness, right? Everyone probably remembers that famous case, right? DeFunis, right? DeFunis v. Oligard, right? It's the law student who doesn't get initially accepted to law school. It's an equal protection analysis. He thinks based on his race, he's not admitted to law school, but eventually they do let him in, right? He actually does eventually get admitted to the school, and he actually graduates, right? And he gets his diploma and degree, right? But it still ends up going to court. And the court basically says, hey, look, even if we find in your favor, right, this issue's already been resolved. You already got your law degree. Even if there was some sort of injury and you can prove that that injury was caused by this law school, right, in the end, right, it's moot, because even if we find in your favor, your injury's already been redressed. The school did eventually let you in, and you were able to get your degree on time. No harm, no foul, right? Third element's not met. This is mootness doctrine. If a case is moot, it's not justiciable. The federal court does not have the power to hear and decide the case, right? So that is power of the feds, Article 3, right? Federal courts and the Supreme Court. Next, we have Congress and the enumerated powers. Right here, what we're thinking about is on a bar exam fact pattern, anytime we see Congress passing some kind of law, right? Congress is passing an act. It's very common. We'll see this on the bar exam, right? The bar examiners will tell you Congress has enacted a Federal Gun Safety Act, and they'll start telling you about the act. Anytime you see that, you're going to want to ask, does the federal government, does Congress have the power to take this action to pass this law, right? And the question is going to be, under Article 1, Section 8, what enumerated power are they relying on to enact this law, right? And the big ones that we're going to be thinking about, especially on the bar exam, are going to be the taxing power, the spending power, and the commerce power, right? The power to regulate interstate and foreign commerce, right? Taxing power and spending power, we are usually pretty easy to see, right? Taxing power, we know Congress has the power to tax as long as Congress can show some reasonable relationship between the tax and revenue production, right? Generally, the tax law is going to be upheld. Spending, they just have to show that the spending that's being done is to provide for the general welfare of the public. Both of those requirements are usually very easy for Congress to show, right? What's more commonly tested in the taxing and spending powers is actually sometimes more of what I would think of as a federalism issue, but we can talk about it here, right? Where you're going to see the federal government, Congress, is really trying to entice the state governments or incentivize the state governments to enact some type of legislation. And they're using the taxing and spending powers to do this. Right, very famous case here would be South Dakota v. Dole, right? Where Congress is trying to condition federal highway funding, right? It's 5% of federal highway funding on all states maintaining a legal minimum drinking age of 21, right? So they're basically saying, hey, look, to get this 5% in federal highway funding, you have to maintain a minimum legal drinking age of 21, right? So most states, all states, want that 5% of federal highway funding, so they maintain a minimum legal drinking age of 21. That's perfectly constitutional. The federal government is allowed to use the taxing and spending powers to encourage state activity. But what they can't do is make it so burdensome, so overwhelming that it amounts to actually commandeering or commanding the states to take certain action, to enact specific regulatory schemes, right? So if in that case the Congress had conditioned 100% of federal highway funding on maintaining a minimum legal drinking age of 21, that would probably be overturned, right? That's commandeering. You're really compelling the state. You're commanding the state to enact a specific regulatory scheme, which they're not allowed to do under the taxing and spending power, right? Taxing and spending power they can use to incentivize, to encourage, but not to command. So you want to just look for that balance. That's kind of the area of taxing and spending power I would say is more tested, right? When we're thinking about enumerated power of the feds, something to look out for. You want to look out for that commandeering limitation when a tax or spending incentive really rises to the level of commandeering, not encouraging, right? But the big one, and the one we really want to be aware of, is the commerce power, right? We know Congress has the power under Article 1, Section 8 to regulate foreign and interstate commerce, right? So what is this, right? There's usually going to be three things here. We know Congress has the power to regulate under the Commerce Clause, right? That's going to be the channels, right? Channels of interstate commerce, right? This would include things like roadways, waterways, anything that transports goods, services, money across state lines. Things like even wires digitally, right? Wires that go across state lines, right? Any channels of interstate commerce, right? Congress has the power to regulate. Think about wire fraud, right? Anything moving across state lines, even if it's digital, through wires, they can regulate it, right? That would also though include roadways, highways, waterways, airways, right? Any channel that goods, services, or money moves through, Congress can regulate. Also, we have instrumentalities, right? Instrumentalities. This is the people and the goods and money that actually move through the channels, right? Think about an airplane and the flight attendants on the airplane, the trucks and the truck drivers, right, whatever, anything that moves through interstate commerce, right? The instrumentalities includes those objects that are being moved and the people who are operating those vehicles, right? Or who are involved, or, right, like I said, the flight attendant and the plane, those are all instrumentalities. So if you see Congress passing laws that regulates, something to do with flight attendants, flights, pilots, right, anything that's moving through interstate commerce, they're going to have the power to do that, right, under the instrumentalities branch of this analysis, right? But the big one, and what it usually comes down to on a bar exam fact pattern, is any activity. Congress has the power to regulate any activity that has a substantial effect on interstate commerce, right? So what is a substantial effect, right? What is an activity that has a substantial effect on interstate commerce? Well, this analysis really comes down to whether the activity is commercial or non-commercial, right? Commercial or non-commercial, right? If something is commercial, right, the activity is commercial or economic in nature, right? Classically think about growing or producing crops, right? Producing any type of, right, anything though that's going on in a workplace that's related to, commerce, commercial, economic, right? Anything about producing goods, exchanging money for goods, anything that's service-based. We know probably what commercial and economic activity looks like versus non-commercial, right? But the key is, if it's commercial activity that's being regulated, Congress is allowed to use what's called the aggregation doctrine, right? The aggregation doctrine, probably made most famous by Wickard v. Filburn, if you remember this case, right? Where the farmer says, hey, look, I'm growing wheat for my own personal consumption. This has no effect on interstate commerce. I'm literally growing this food for my own personal consumption, right? And Congress is saying there, sure, maybe you as a one individual farmer, right, that doesn't have an effect on interstate commerce, the amount of wheat you're growing for your own personal consumption. But if we looked at every individual farmer in the aggregate and how much they're producing, right now we can see how that does have a substantial effect. So if we can apply the aggregation doctrine, almost any activity will then have a substantial effect on interstate commerce, right? So it all comes down to whether or not we can apply the aggregation doctrine. And if it's commercial activity, like producing crops, then we can apply the aggregation doctrine. But if it's a purely non-commercial activity, a non-economic activity, think United States v. Lopez, possession of a gun in a school zone, right? Possession of a gun in a school zone, educating children, that has nothing to really do with commerce, right? That's not really commercial or economic, right? Especially the education of children children freely at a public school, possession of a gun, really not a, economic or commercial activity, right? So you can't apply the aggregation doctrine to that activity. That's really not possession of a gun in a school zone, something that's going to have a substantial effect on interstate commerce. Now, possession of a gun in a workplace with 100 or more employees, right, an argument could be made. Well, maybe that is more commercial in nature. When we're talking about an office and employees getting something done, doing work, we could see how that might have a substantial effect in the aggregate, because that's more of a commercial activity. But pure possession of a gun in a school zone, that's the United States v. Lopez, can't apply the aggregation doctrine, right? That's not an activity that has a substantial effect on interstate commerce, right? So Congress cannot enact that law under the Commerce Clause, right? They're not going to be able to regulate possession of guns in school zones under their commerce power. Congress, right, the federal government doesn't have the power to take that action, right? It goes up to our very first bucket element, our very first main issue, right? So that's what we want to think about in terms of the commerce power or the Commerce Clause. Next, kind of our last major issue in this first category, when we're thinking about powers of the feds, is going to be the President of the United States taking action. Thank you so much for watching this video preview of our Bar Blitz video series. If you would like to see the conclusion of this video and gain full access to our entire Bar Blitz video library, which includes coverage of the most frequently tested and highest yielding areas of law in each bar exam subject, we invite you to head over to our website and join the thousands of law students who have already enrolled in Studicata Bar Review. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com.